Even if it's eventually, I mean, I think people just don't want to live in uncertainty or take a risk, but it's given some really severe meaning that really undervalues.
Good afternoon and welcome. So glad all of you could come here to join us at Catholic University for this wonderful panel. Gorgeous weather outside and you're not playing hooky. I'm impressed. We're thrilled to be here to discuss this important topic with this fabulous panel of speakers. I'm Professor Elizabeth Winston, and many of you have been my students and are currently my students. And to the rest of you, I will look forward to learning along with you.
Hello, everyone, and welcome. Thank you for being here. I am Professor Megan LaBelle, and we're looking forward to a really interesting and exciting discussion today. So some of you didn't have a chance to sign in, so I'm going to, if you want CLE credit, I'm going to distribute this around the room. Just make sure that we have your email address. So most of your names are on here. If we don't have your email, please provide it. If your name's not on here, just write your name and your email so we make sure we get the information you need for CLE credit. So thank you again for joining us this afternoon. We will turn it over to Judge Damage, who's going to be our moderator today.
Thank you very much, professors. I'm going to give a brief biography of each of the panelists, but I thought I'd give a little biography about me, too. I'm a judge on the Court of Federal Claims, but the most important thing is I'm a graduate of the law school, and this institution has seen fit to hire me also as an adjunct professor. I do a seminar in copyright and trademark law in the fall semester. So any students here, you can all sign up. On our panel today, we have a representative from the legislative branch, and I can't help but reminiscing about the time that I was on the legislative branch. Also, I was once Chief Intellectual Property Counsel on the Senate Judiciary Committee. So we're very happy to have someone from Congress speak. The format today will be a presentation from each of the panelists for about 10 minutes, followed by a brief period whereby the panelists will be invited to comment on each other's presentations or to make any comments that they think are relevant to the topic. And then we'll open the floor to questions from all of the patient people in the audience. Despite this seating order here, we're actually going in a slightly different order as far as speakers are concerned. Mr. Mittal will go first, followed by Judge Smith, then Ms. Janet Gongola, and finally Ms. Antigone Payton. So let me first introduce Joe Mittal. Mr. Mittal has been a Judiciary Committee counsel to Senator John Kyl since 2002, except that he served as the Republican General Counsel of the committee while Senator Jeff Sessions was the ranking member from 2009 through 2010. He's one of the principal legislative staff involved in the drafting and floor management of the America Invents Act, which, as you know, is what we're talking about, and recently published the first part of a two-part law review article about the legislative history of the Act. Joe has also worked as an associate attorney at Gibson, Dunn & Crutcher, as a law clerk to a judge on the U.S. Court of Appeals for the Ninth Circuit, and is a 1996 graduate of Boalt Hall School of Law. Our second speaker, Chief Judge James Donald Smith, was appointed to the Board of Patent Appeals and Interferences as the Chief Administrative Patent Judge effective May 8, 2011. He received the Juris Doctor degree from the School of Law at Duke University and a Bachelor of Science degree in Electrical Engineering from the University of Maryland at College Park. Judge Smith has had a long career in the law and in intellectual property, including a brief time as an examiner at the USPTO. A former assistant dean of the law school at Emory University in Atlanta, Smith also served as a clerk at the Federal Circuit to the now retired Chief Judge Paul Michel, as a patent litigator and patent prosecutor, and he led international licensing and day-to-day management of in-house IP teams for three multinational corporations, Lexmark, Nokia, and most recently Baxter International, where he served as Associate General Counsel and Chief Intellectual Property Counsel. Our next speaker, Janet Gongola, is the Patent Reform Coordinator at the U.S. Patent and Trademark Office. In this capacity, she manages all aspects of the agency's implementation of the America Invents Act. Previously, Ms. Gongola was an Associate Solicitor in the Office of the Solicitor at the USPTO. Ms. Gongola served as a law clerk for the Chief Judge Paul R. Michel, two representatives here, at the Federal Circuit, and for Chief Judge Sue L. Robinson in the U.S. District Court for the District of Delaware. Ms. Gongola also worked as a patent attorney, patent agent, and research chemist at Eli Lilly and Company. Finally, last but not least, of course, Antigone Payton is the founder and CEO of Cloudagy. Is that how you say it, Cloudagy? Cloudagy Law, an IP and technology boutique law firm. Before Cloudagy, she practiced at the IP firm of Finnegan Henderson in Washington, D.C. Antigone has also worked for Judge Moore at the U.S. Court of Appeals for the Federal Circuit and Judge Luckern, the former chief ALJ at the International Trade Commission. Before law school, she wore the hat of a scientist and conducted preclinical and clinical experiments involving magnetic resonance imaging at the University of Pennsylvania Departments of Radiology and Biophysics. So we have a very distinguished panel today and limited time. So let's begin. Mr. Mittal.
Thank you. I guess since I work for Article 1 in the Constitution, I get to go first. I'm first going to give you... Oh, should I go up there?
Do you have a slide presentation?
Oh, yes, I do, actually.
Yeah, so then it's easier with the remote and the pointer. Thanks.
See, just out of curiosity, this is to advance or which one?
Yes, I think so.
Let me just try it out. Oh,
First we have to get it up.
I guess I should stop pressing buttons.
Just take this. You want to show him now how to...
Which one is forward? That one and that one's back. Okay, great. Thank you. My name is Joe Mittal. I'm a counsel to Senator John Kyle on the Senate Judiciary Committee. The America Invents Act is most of what I've been working on for the last 5 years. And the 6 months since the law, since the act was signed into law, I've spent as much time working on it since it's been enacted as I did before. This was a massive statute. It's the first comprehensive bill Congress has done since the 1952 Act. And in terms of the depth of the changes it made, many people say it goes back to the 1836 Act, which first created the system of patent examination. Before, the 52 Act and another major act in 1870 were both basically codifications. And this act didn't try to just catch up to what the courts had read into the statute. It tried to change a lot of things. And by far the biggest and most important change that this made, and one that'll affect all of your careers as patent lawyers for the rest of your lives, is switching to the first-to-file system. First-to-file is something that in any official report or study was first recommended by the Lyndon Johnson Commission report in 1966. So, and it's been recommended by a number of studies and reports since then, including important ones by the National Academies and the FTC in the early part of the last decade. No one can accuse Congress of having rushed this matter. The Act also makes fundamental changes to the definition of prior art. It creates a limited prior user right for the first time in the patent code since the mid-19th century. And it creates several new post-issuance administrative proceedings and substantially revises the existing administrative proceedings. And one other interesting thing that you all will deal with over the next 2 decades of your careers is that because you can't change the rules of prior art or patent priority retroactively, all of you, if you become patent practitioners, are going to be living under both the first-to-file system and the first-to-invent system for probably the next quarter century. The Act's transition to the first-to-file system doesn't kick in until March of next year, so only patents that claim subject matter that was added to a patent application after March of next year will be subject to first-to-file. Every patent that only relies on subject matter entered into an application before March of next year will still be a first-to-invent patent, will be valid for 20 years after the filing date. And so lawyers for the next quarter century are effectively going to have to know and operate under both systems. I'd like to also, from that broad overview, dive into two specific issues. And some of the materials that have been distributed address the issues of first-to-file and supplemental examination. And since I worked on this thing and helped get it done, it's my job to defend it, and that's what I'm going to do. So the argument, and this right here is the new 102A, what effectively implements the first-to-file system. First-to-file is effectively implemented by the fact that a patent's priority date is now the effective filing date rather than the date of invention, the date that the inventor conceived of the patent. And the argument is often made, and is made in some of the materials that have been distributed to you, that this will be bad for small inventors, et cetera. So why did Congress do this? And people get into all these interest group theories. Well, the reason is we thought it would be good for small inventors, and let me explain why. First of all, the notion that under the first-to-invent system, small inventors are protected because they can just rely on their date of conception rather than having to file and go through the burden and expense of filing. The notion that that system of proving a date of conception after the fact protects small inventors is completely illusory. First of all, if a small inventor gets into a battle with a big company over who has the right to priority in a patent, you'd normally go into an interference proceeding, and the American Intellectual Property Law Association estimates that it costs about $600,000 in legal fees to go through an interference. So guess what typically happens in an interference? The big corporation grinds down the small inventor, and in the end, it doesn't matter who invented first. The small inventor just runs out of money and gives up. And the Patent Office actually ran the numbers on this, to try to substantiate this argument, and they found, I believe they went back 7 years, and over a 7-year period, they found one case where an independent inventor, who was the later filer, actually prevailed in an interference proceeding. That's just because the odds are so stacked against you. The other argument that's often made, and is made in some of these materials against first-to-file, and we dealt with all these arguments in Congress. They were made on the Senate floor as well and House floor by opponents of first-to-file, is that it's so easy to rely on the first-to-invent system and so burdensome to use the first-to-file system. Well, under the first-to-invent system, once you get in a dispute with someone or you need to swear behind prior art, you don't just get an affidavit from your mother that you invented first. You actually have to prove that you did, and you have to produce documents and records that show you had a definite and permanent idea of the complete and operative invention. That is, that basically you had possession of the invention. And those documents have to be validated by a third party, but under the pre-AA system, you can't give that third party control of the invention without signing a non-disclosure agreement, because that becomes an invalidating public use that wipes out your rights. So first of all, with all these rules, the idea that an unsophisticated inventor just dedicated to science and plugging away is going to incidentally comply with all of the rules that will later allow him to prevail in an interference proceeding, for example, is completely illusory. You already had to be pretty legally sophisticated to take advantage of the system. Secondly, it's pretty easy to explain to people you just have to file, and the only thing you have to file is a provisional application, and the only thing a provisional application has to show is 112A description, a written description that shows you what the invention is and how to make it and use it. That is, that you had possession of the invention. In other words, the very thing that you would have had to show under the first-to-invent system through your documents and records is effectively the same thing that you're going to have to show in a provisional application. The difference is it's a government document that's date stamped. There's no disputes about validating it. And it's public. The rest of the world can know what priority date you're going to claim as well later. So anyway, in a nutshell, that's the case for going to the first-to-file system. The materials that I gave you in the handouts that you got include debates from in the Senate that make a lot of these points as well, if you're interested in diving a little deeper into some of these issues. Another provision of the bill that I'll defend today is supplemental examination, and some of the materials you received characterize it as patent amnesty, where letting someone get away with something dirty and somehow it's going to hurt patents overall. Well, the first thing I'll point out is that, especially after the TheraSense decision from the Federal Circuit, the only patent that's going to be wiped out under the doctrine of inequitable conduct is one that had something in it that was already invalid. What supplemental examination allows you to do, it'll be Section 257 in the new code, is if there's a potential issue that you think could be inequitable conduct, you can return to the patent office with that information and say, this study, this information, this other fact maybe should have been looked at. Can you take a look at this? And if the patent office either decides there's not even a substantial question, or they look at it and they validate your patent again, they find it's valid, then that issue cannot be raised against you again as inequitable conduct. And the reason for doing this is right now, especially pre-TheraSense, the doctrine was so broad. First of all, it was raised in most patent litigations and created expensive discovery issues. And frankly, just the cost of enforcing the doctrine grossly outweighed any conceivable benefit of it. But secondly, it created huge uncertainty. And you often got situations where a study that was clearly cumulative maybe could have been, and that certainly doesn't affect validity, nevertheless could be raised as an inequitable conduct issue. And people look at this and say, the scenario where this is a real problem is you get a small inventor, an independent inventor, sometimes a university researcher inventor, and they did a good enough job with the patent prosecution, but they didn't introduce that cumulative study. They didn't introduce, they didn't do a scorched earth application. They didn't know all the sharp corners that sometimes need to be turned under the inequitable conduct doctrine. And someone is looking at purchasing that patent later and says to themselves, well, I'm sure the patent is valid despite the failure to introduce this information, but am I really going to invest millions of dollars in purchasing and developing this product only to get burned in potential inequitable conduct litigation 10 years down the line? What supplemental examination does is it gives you certainty. You take that information back to the office, they examine it, decide whether it raises a substantial question or if the patent's valid, and then you know for sure whether you have a valid patent and one that will survive an inequitable conduct attack. And finally, I'm sure I'm over time by now, as to the argument that this is a patent amnesty, well, yes, it's an amnesty for people who didn't do anything wrong. Because the only way you get amnestied through supplemental examination is if your patent is a valid one. If you have something that creates potential inequitable conduct invalidity, it's going to be invalidated in inequitable conduct, and the lawyer who was involved will probably be subject to a Section 32 sanctions proceeding. So it doesn't sound like too much of an amnesty to me. So anyway, these issues are also addressed in greater depth in some of the materials that I provided for you.
Thank you very much, Mr. Mittal. Judge Smith.
Good afternoon. Where we are right now with implementation of AIA is at a quite significant juncture. Just this past week, the period for commenting on the proposed new rules relating to the board operations and the new proceedings it will have before it, that period for comment closed just last week. The AIA has proven to be the provoker of many, many comments, and we are in the process of digesting those comments. I thought it might be interesting, therefore, to share with you sort of a top 10 list, at least with respect to the board proceedings, as to what the most interesting issues seem to be to the public, or at least the ones that where there is enough difference of opinion as to whether we have treated those things properly as to induce comment. Before doing that, however, just a few things about the board proceedings that come to or the proceedings that come to the board by way of the AIA, so that those of you who are less familiar with that will be able to make something more of the top 10 list. Currently, the board has two real sets of jurisdiction. Appeals that arise from examination where a final rejection has been issued in a patent prosecution to an application, and the unsuccessful applicant is permitted to appeal the decision of in examination and obtain a final agency ruling that is then appealable to the U.S. Court of Appeals for the Federal Circuit. That makes up a substantial portion of our jurisdiction, and as of last week, I think we had 26,600 of those cases waiting for decision before the board. We're working on that, but that's another subject for another time. Separately, we hear interferences, appeals from reexamination proceedings, both inter partes and ex parte reexaminations. Our jurisdiction changes with the AIA, and we add to that jurisdiction 4 proceedings. You've probably heard them spoken of already: inter partes review, post-grant review, transitional program for covered business method patents, which we more economically refer to as CBM, and derivation proceedings, which are sort of the child of interferences. There's much to be said about each of those proceedings. Let me just say this briefly about each of them. Post-grant review is essentially a proceeding which one must invoke 9 months after the grant of a patent in order to challenge its issuance. And it is a somewhat broader category of challenges that are permitted under that review. Inter partes review persists for a longer time, beginning after the period of post-grant review ends, and has a much narrower scope, 102 and 103 issues, for those of you familiar with Title 35. And that's by design, so that the reasons for knocking out the patent narrow during the course of its life. Essentially, during the post-grant review period, the first 9 months, a challenger is permitted to bring forth a fairly wide number of issues. Title then becomes relatively more quiet if it's decided in favor of the applicant, and then a narrower set of challenges are possible thereafter. Those challenges themselves being somewhat limited by the fact that the challenger, having raised particular grounds of unpatentability and lost, is precluded from raising those particular grounds again. At least that challenger is. Transitional program for covered business method patents, or CBM, is a form of proceeding, most like post-grant review, and is directed at a particular type of patents, business method patents specifically. Derivation is, I say, child of interferences because, of course, as Mr. Mittal was explaining, we are in a whole different world once we move into the first-to-file regime. That said, it is still possible that an applicant may be proceeding with claims that are like the claims in another application or already issued patent, and that applicant may claim not only that will claim first that she is more properly entitled to the patent, not so much by virtue of date. In fact, the party taking the action there will have filed later, but then can show that the earlier filing was based on information obtained from the later filer. So basically something more akin to a conversion action than simply to a contest over who invented first. So those are the 4 basic proceedings, and just 4 points of terminology which apply to them generally. The 4 of them are, in fact, called proceedings. That's a significant term in contrast with 2 or 3 of the other terms. Once a proceeding is brought, the first part of the proceeding is the filing of a petition by the party who wishes to challenge the patent. That petition, and again, that's a very particular use of the term because in board proceedings, in board world, we use the term petition in other contexts differently. When the petition is brought forward by the challenger, that petition must make out a sufficient reason for invoking a trial. If the trial is instituted, then during the course of the trial, which would conclude in a final determination, the parties are permitted to file motions for various relief and other things to happen during the course of the proceeding through the trial and to its conclusion. So against that backdrop, what things are the public saying are of concern to them? Much to my surprise, at the top of the list, issues are being taken with the page limits prescribed in the rules. And since most of the comments come from lawyers, what do you think they are protesting? Of course, that not enough pages are being allowed, which is really, it's amazing to me actually, because the proposed rules specify 50 pages, 70, 50 pages as an example for various types of filings, for petitions and the like. And the lawyers, Mr. Stern maybe can tell us his reaction to this, have said, no way, not enough. And one of the particular strains of those set of comments have to do basically with this. What if the patent has 100 claims in it? How in the world are we going to make our case in only 50 pages? And there are those who think that there should be no page limits at all, that the board is somehow, or the proposed rules as put forward by the agency, somehow seek to unduly constrain the First Amendment rights of petitioners and patent owners. Generally in response, and without prematurely commenting as to the outcome of final rules, I would say that, and Judge Damage can confirm this, he does see page limits in his court. The discovery, the scope of the discovery is another source of dispute. Should parties have to come forward, for example, with inconsistent statements? That touches very much on the issues that Mr. Mittal was speaking to with regard to, for example, supplemental examination and duty of candor before the office. How narrowly should estoppels apply against those who've challenged patents? That's a big subject. It is not so surprising to me, number 4 on the list, which I actually thought would have been number 1, fees, because of course money is always an issue, and some of the fees proposed with regard to the board proceedings are relatively high in comparison with fees in the past. I will touch quickly on the remaining issues, and maybe they can be the subject of some later discussion by the panel. Should broadest reasonable interpretation be how the judges look at the claims when construing them, or should we take the approach taken by courts in the Federal Circuit to preserve validity? Which attorneys should be allowed to appear in the proceedings? The proceedings are before the office, but there is certainly much interest in those not registered to practice before the office also to participate in these proceedings. To what extent should patent owners be allowed to seek leave to amend the claims of the patents? Another big subject. Should the proceeding go on a claim-by-claim and ground-by-ground basis? That's another area of much comment. Supplemental information, how much additional opportunity for discovery after initial discovery should be allowed, and the definition of which proceedings actually are exempted from covered business methods, even though certain areas, certain types of inventions are business methods, but nonetheless for various reasons defined out of the scope of coverage. That's received a lot of comment. So that's just a quick look at some of the implementation dialogue ongoing currently. Thank you.
Thank you, Judge Smith. Ms. Gongola.
Well, good afternoon, and thank you to Catholic Law School and Professors Winston and LaBelle for inviting me to participate on this wonderful panel this evening. Now, the way I want to structure my next 10 minutes or so with you is to talk about where the agency has been in terms of implementing the America Invents Act and where we foresee going in the future. So across the first couple of slides, and I'm going to kind of group the America Invents Act in all of its grandeur into 3 categories: provisions of law that the agency has to implement, studies that the agency must conduct, and new programs to benefit patent applicants that the agency is expected to roll out. So on slides 2 and 3 in your packet, and I won't talk about each of the bullets, that's the type of information that I'm focused on. And these particular slides 2 and 3 cover milestones that we have completed. So focusing on new provisions of law, the agency has implemented 7 provisions of law within the first 60 days after enactment. 2 big ones to note are prioritized examination, which enables an applicant to secure a fast-track examination in front of the office within a period of 1 year from the date we institute the proceeding. And thus far, the agency has granted prioritized examination in 98% of all requests. The second provision we've already implemented is to tack on a 15% surcharge onto all of the patent user fees. The 15% in the aggregate is the money that the agency is using to fund our implementation efforts, hiring examiners, updating our automation systems. Now, today, we are working on implementing 9 additional provisions. 5 related to patent operations, provisions like changing the inventor's oath and declaration requirement, supplemental exam that Mr. Mittal talked about, pre-issuance submissions by third parties of prior art in an application, also third parties' ability to submit patent owner statements into an issued patent file, and the OED statute of limitation changes. And then on the board side, as Chief Judge Smith relayed for you, we have 4 proceedings: post-grant review, inter-parties review, covered business method review, and the derivation proceedings. So I'll talk more, but we issued through January and February our notices of proposed rulemaking for all of you to consider and provide commentary on. In turn, March, April, the public comment periods have closed. And momentarily, I'll tell you a little bit more about the scope of the comments that we've received. Now, on the studies front, we have completed 2 of the 7 studies we are required to do for the American Invents Act. The studies were the International Patent Protection Study, which asked the agency to investigate ways that the government, or in particular the Patent Office, might help small businesses financially secure foreign patent application filings. The report was pretty extensive, and I'll give you one recommendation. We recommended in our report that the government help to better educate small businesses on the benefits of foreign filing to enhance the value of their patent estates. And the report made 5 additional recommendations that I'll let you read, or if you have questions, I'll take them during the panel time. Now, we also completed our prior user rights study, which asked the government to analyze the scope of our prior user rights law as compared with other industrialized nations. We recommended that Congress not alter the prior user rights law at this point in time because it's brand new. But we recommended that Congress also reevaluate the law once the agency prepares in 5 years from now a study on the scope of AIA implementation across the board. Now, the last area that we have completed on the program front, we have rolled out our pro bono program, which was really in effect on the date of enactment. There's a program running in the state of Minnesota to connect pro bono independent inventors with attorneys to help them file and prosecute their patent applications. We are working on a task force right now, along with the Federal Circuit, to help expand that program to other cities. And then the second program we completed was a rollout of a study for methodology to define the diversity of our patent applicants. Now, our methodology is twofold, backwards looking and forwards looking. On the backwards looking end, the agency is working on a memorandum of understanding with the Census Bureau to be able to tap their records for diversity information, race, gender, veteran status, for past filed applicants. And our goal is for the Census Bureau to produce an aggregate report for the agency, meaning that we wouldn't connect diversity data for an individual applicant, but instead the Census Bureau would provide us a report saying, and I'm totally making the numbers up, 10% of your applicant population is Native American, 50% are female, etc. Then looking forward, the agency plans by the end of June to publish a request for information in the Federal Register to collect thoughts from all of you about how we can access diversity information going forward. Should applicants, in the form of something like an application data sheet, be required to provide diversity information to us? Additionally, looking forward, we want to figure out a way that we can tap diversity information for foreign applicants. 50% of the agency's applicant filings come from other countries, and the Census Bureau will not help us access that information. Okay, now looking to the scope of the public comments that we've received to date. This is the first time I'm sharing this information, so you are my prize audience this evening. So this is a breakdown of the comments that we received for the patent-related provisions. And you can see we have 123 comments across the 5 provisions. On average, we received 28 comments per provision. However, you'll see that entry number 3, the OED statute of limitations, only received 5 public comments. So that's pulling down that average ever so slightly. Now, you might be wondering, where did these comments come from? Well, on this slide, I've broken down for you the identity of the commenters. The majority of comments on the patent-related provisions came from individuals, followed by a close second from IP law organizations. So the pie chart shows you the percentage breakdown of the total comments represented here. You'll notice that government institutions did not provide us any comments on our patent-related rulemakings. Now, for our board-related rulemakings, we received double the number of comments, 251 total comments, with an average of 42 comments per provision. So I'll let you look at the rundown of the numbers. And on the next slide, I feature for you the identity of these commenters. And unlike for the patent-related provisions, the majority of comments here on the board rules are coming from individuals and companies, and then followed by IP law organizations. So what the agency is doing, we're looking at each and every one of those comments from the teams that are going to be drafting the final rules all the way through up the director and the deputy director, figuring out from those comments what the public did not like, what the public liked, and suggested recommended changes. Already you've probably seen some dialogue where we've tried to tell you as we've been going on, as Chief Judge Smith has done today, areas where we are already aware that the public has concerns and that we are going to address in our final rules. Now, I can't tell you at this point exactly what changes we will make, but suffice it to say that you will see some differences in our final rules in hotspot areas from what we propose to the public. And to that end, that takes me into what's to come in the future. And I'm only going to take us out through the end of the summer to let you know what activities you'll see from the agency and how you can become involved. So those activities are featured on slides 8 and 9, and I'm going to cover them in the same way, provisions of law, studies, and programs. So for provisions of law, first, by August 16th, the agency will roll out our final rules for the ones that we've made proposed rules for, inventor's oath, all the administrative trials. Statutorily, we must have our final rules out for your consumption 30 days before their effective date on September 16th. So in that 30-day period, what we're planning, and more towards the end of the 30-day period, recognizing early August is Congress is recessed and vacation season. So towards the end of that period, the agency is planning for a series of cross-country road shows so that we can educate you all on our proposals. We will also be coming out with new notices of proposed rulemaking for our fee setting, micro-entity provisions, and our first inventor to file provisions. First inventor to file, we're going to cover somewhat in the rules, but mostly in a very substantive guidance document. And to help educate you on that guidance document and collect feedback, we're planning in late summer, early August timeframe, a first inventor to file roundtable where you will have a chance to give us feedback. Then quickly on the programs front, we'll be issuing our genetic testing study on June 15th. And then on the programs front, we will be rolling out our patent ombudsman program that has been piloted since October of 2010. We're making that program permanent to help applications that have somehow become clogged in the system. The patent ombudsman can be a point of reference to help jar loose that clogged application. So thank you, and any details on these provisions I'll take during the panel discussion.
Thank you, Ms. Gongola. Agencies love it when Congress gives them these studies to do. Ms. Payton?
All right, I won't take too much time. I think we've covered a lot of interesting subjects already. I want to focus on the practical aspect of everything that has happened and everything that will happen. Obviously, there's a lot of ground I can't cover in a 10-minute conversation, but I really want to talk about the practical impact of what we're rolling out, and in particular, what it means for businesses both large and small. We actually represent multinational companies as well as small bootstrap companies that are just coming into the world of patent law. So it's been interesting to start talking with them about these changes. They've heard a lot. There's a lot of fear factor discussions out there. So I want to break through the hype a little bit and talk about practically what this means. So I think one of the most interesting parts of this change is this idea of secret technology, technology that's not publicly disclosed to the world prior to a patent applicant's filing. That provision is going away. As was previously discussed, we're going to have this transition period where we're living under the old world law sometimes and moving to the new law, but we've really consolidated this idea of prior art into prior art that's public-facing, public disclosures of information. And the reason why is we've had these very complicated schemes we've lived with for many years where we get into these complicated patent litigations or interference proceedings, and we go to the warehouse and we find the old stuff that's not on computers, that's 15 years old, to try to show that our client was the first to invent a particular technology. This is a very expensive process. It's burdensome for clients, I say large and small. The big companies suffer under that original regime just as much as the small companies, but I think for different reasons. The patent effective filing date, Mr. Mittal talked about this a little bit already. I think one of the most significant differences here is currently if there's an international filing and then a subsequent U.S. filing through what's called a PCT procedure, under the current law, the U.S. filing would be the effective filing date. That will be no more. Now we're going to go back to the first international filing when we're talking about the effective filing date, and this relates to the first filing provisions that I'll get to in just a second. Disclosing first. Now this aspect has received a lot of discussion on the floor in Congress, and people continue to discuss strategies with this first disclosure idea. Here's the practical side. If you're a company and you go out to a trade show and you show a prototype or you submit a paper or an abstract and talk about your invention, under the current regime, you have to get your patent application on file within a year, but somebody else might come along and show that they actually had that technology first. And then we get back to that complicated procedure that I discussed earlier. If you actually disclose first and somebody else files a patent application on the same invention, if you get your patent application in within a year, you're entitled to rely on that first disclosure. You win. That's incredibly important. So you'll sometimes hear people talking about get your information out, get your studies out, go to your trade shows. I think we have to have a more thoughtful discussion about what the right process is for particular companies and particular inventions. But this is going to be a subject of significant discussion in the future. Strategically, what should we be doing with things? Should we be protecting them or trying to publicly discuss them as soon as possible and make sure we get our patent application in within that year time period? Our new definition of prior art. So I already mentioned that we had this secret prior art aspect and this public prior art aspect. No more. We've tried to simplify the idea of prior art. And the simple answer is all things public around the world. We used to get into this complex procedure where if we were evaluating something called an offer for sale or a sale, if the activities occurred outside the United States, let's say you were working with a German company and you faxed over the original terms and then the contract to the company, and perhaps you flew over to Germany to sign the contract, is that a sale in the United States? That was a question under U.S. law. Now we're no longer going to have that complication. If it's a public commercial activity, it counts. Prior user rights. This is going to be a really interesting provision. It's a bit complicated. I think there's a lot of areas for industrious lawyers to litigate over these provisions in the future. But the idea is if a company has been using a technology internally, let's say a method of manufacture, well before another company gets their patent application on file that covers the same technology, they have what's called prior user rights. It's a defense, not an offense, so they can't use it to necessarily invalidate the other patent, but the idea is they can say, I've already been using this technology and you can't sue me for patent infringement and actually prevail. Interferences to derivation. We already heard some discussion about this. Derivation is now important because we have provisions that relate to protection for either inventor disclosures or third-party disclosures on inventors' behalfs. We also have this question that was discussed heavily when the American Invention Act was going through the past Congress. And people were concerned that somebody would file something that they didn't really invent. And they might have heard about it from somebody else. We needed some process to deal with that. So derivation is our process. Supplemental examination. I call this the mulligan, and I use that tongue-in-cheek. But, you know, really, people find this provision very controversial. I don't. Inequitable conduct is the bane of lawyers' existence who litigate. We see it in every single case. There are these wild allegations of inequitable conduct. TheraSense, as was already mentioned, has taken care of this standard and raised the bar for showing inequitable conduct to a much higher standard than some panels at the Federal Circuit used to use. But I think this is the nail in the coffin. The idea is patent prosecution processes aren't necessarily perfect. You might have files sitting at a company where people forgot about a collection of information, or somebody discovers something after a patent application actually issued as a patent. This is the opportunity to go back to the patent office, tell them about additional information you think they should know about, and let the patent office make a decision about whether it's a problem for people. We've always had standards for attorneys and for applicants who practice before the Patent and Trademark Office. We owe a duty of candor to the office, just as we do to courts. And so I don't think that this really gives us the opportunity to sort of throw one over on the office and try to fix bad behavior in the past. Post-grant, I threw a lot of stuff in here. Along with supplemental examination, the idea is we are becoming more like other countries who have significant proceedings at the patent office to allow either companies, inventors, or third parties to give the information to the patent office that they think they need to make a decision about an application that's already issued as a patent. A lot of discussion has occurred about this asymmetry of information, the need to give the patent office more information, and the current proceedings are relatively limited. It's hard to get certain information in front of the office. So this is really opening up the opportunities and giving the office a number of different programs and the parties a number of different programs to give information to the office and have them make a decision about whether there's a problem with a particular patent. Infringement opinion. I think this is fascinating. So, we've had a lot of discussions in the court about the intent requirement for willful infringement and for induced infringement. They've actually codified it now, which means that we can't have the creep and case law that we sometimes see with other doctrines. And very quickly, marks. Patent marks on particular products. This has been a real problem in litigation. Enterprising attorneys would go after companies that had expired patents on their products, or put a particular patent number on a product that didn't necessarily map. That process has basically ended now, and the government has to go after them unless you really show a commercialized harm for your company. Then you can sue them. Finally, the troll game. There's been a lot of discussion about patent trolls. I'll briefly finish up with the idea that now, just because somebody has a patent and they want to sue a particular field, let's say it's mobile technology, they can't file against 20 defendants just because they allege that they infringed the same patent. There have to be facts and circumstances in common with all these defendants. This provision was rolled out when the AIA was signed into law, and I'll tell you, the day before, there was a slew of filings at the office. I haven't really seen a reduction in the number of what we call non-practicing entity or troll filings. There's just more individual filings, but they're still happening in the same court. So it will be interesting to see when somebody actually looks at this a few years down the road, whether it has curbed the troll filing program or not. And that's it.
Thanks very much, Ms. Payton. We now have a few minutes, maybe about 5 minutes, for the panelists to comment on each other's presentations or supplement, emphasize, whatever you want to do.
Well, the rest of you did a great job.
Yes, and you pretty kept to the 10 minutes, too, which is really good. No? Nobody? All the better for the floor. Any questions from the floor, then? Yes, sir. And speak loudly, please.
I have a question specifically for Mr. Mittal. One of the things that has received some debate and review is the question of the metallizing engineering case and the notion of prior use, that now, if it's not a detectable prior public use, this technology can be used indefinitely before being presented for patent. So is that, in fact, the intended case in the American Invents Act? And the other question is, how then would this issue of invalidating prior use under the old system and non-invalidating prior use under the new system comport for patent applications that are referring to uses and technologies developed when the old law was enforced but filed under the new law?
I'll answer your second question first. It'll just depend on the effective filing date of the patent. So if it's a patent that only relies on subject matter added to the application before March of next year, then metallizing engineering is still good law, and secretly commercializing your invention in the United States in a way that doesn't reveal it to anyone more than a year before your filing wipes out your right to patent. And under post-AA law, and by the way, there are some tricky things in the transition provisions that could effectively make you subject to elements of both regimes. The moral of the story is never mix claims. Make sure you keep all of your effective filing dates of your claimed inventions on one side or the other. But if you're purely on the other side and purely in first to file, you're also subject to the new prior art definition. And the operative language at the end of the new definition of non-patent prior art, 102A1, is otherwise available to the public. That's meant to both indicate the breadth and the limits of the definition of prior art. So commercializing an invention is only prior art if it effectively makes the invention available to the public, meaning someone who's interested in the subject matter would have been able to discover the invention and appreciate it through reasonable diligence. In effect, yes, you can commercialize the invention for well over a year and still file a patent application. You can do that under pre-AA law as long as you build your factory in Germany, because it was only these secret uses in the U.S. that inventors were punished for. But again, under the new law, the fundamental inquiry for determining whether something is prior art or whether the invention is patentable ultimately is whether the invention was in the public domain, whether the interested public would have been able to access and appreciate the invention before the relevant dates.
Any other comments from the panel? Yeah.
I have a follow-up question, if I may, for Mr. Mittal on this. Earlier, Professor Winston mentioned, Judge Damage, in the introduction that Mr. Mittal has written a paper about the legislative history of the America Invents Act. If you haven't read it, I highly commend the paper to you. It is a wonderful explanation about how certain provisions came into being, what the intent behind them was. The question that I have is, I've heard about a colloquy, and you can read it in the history between Senators Leahy and Hatch regarding the sale provision and whether it overruled metallizing engineering. But I've also heard commentary, well, that's not really the legislative history because the colloquy happened after the vote. So I'm wondering if you could speak to that a little bit and maybe educate us on what is the legislative history comprised of?
The colloquy appears in the record on March 9th, and the America Invents Act first passed the Senate on March 8th, so this is a colloquy that's in the record the next day. If the Senate's action on May 8th had been, or March 8th, had been the final action on the bill, it wouldn't be legislative history. There's actually a great D.C. Circuit opinion condemning post-inaction legislative history as not even being legislative history, that's legislative future and carries no weight. However, after March, the bill then went to the House. The House basically did its own bill, but a bill that was about 98% identical. Not all of these operative provisions, the new 102 was identical. It's clear the House was even aware of that colloquy. It's even discussed at various points. A similar colloquy was done by the lead House sponsor and another member. And Senators Leahy and Hatch, by the way, are Senator Leahy is the chairman of the authorizing committee and lead sponsor of the bill, and Senator Hatch is the lead minority co-sponsor of the bill. So they're fairly authoritative as to as to the intent of the drafters. The House also issued a committee report for the bill in which, just to clarify this issue and try to put this to bed, they even cite to that colloquy to help elucidate the intent and the how this language should be understood. And again, the House sponsor said effectively the same thing in a colloquy on the House floor as well. And then after the bill passed the House, it actually went back to the Senate again. So again, if nothing had happened after March 9th, this wouldn't be legislative history. But given there was action later, and it was clearly even contemplated and repeated in the House and referenced in the committee report, the Leahy-Hatch colloquy is on pretty solid grounds as legislative history.
Great, thank you. Any other comments from the panel? I believe there was a gentleman in the front here.
Yeah, I just had a question about, it seemed like there was a tension in the best mode future. Now, there was a specific item that said best mode is no longer going to be a defense, and yet best mode is still part of 112 first. And I just wondered, and I remember hearing something about, well, you're still going to have some leverage to make an invention disclose best mode because the attorney will get in trouble, and there are some other things. And I wondered sort of a crystallization of, is best mode just going to have to be resolved in the courts, or is there
Well, the bill, it doesn't repeal best mode, but best mode can't be used, the failure to disclose best mode can't be a basis for rendering the patent invalid or unenforceable or denying you the ability to rely on a parent application for an effective date. So I think in one webinar it was described as the end of best mode, long live best mode. It's a it's just the sausage factory at work. It's not the way I would have drafted it, but no one gets their way of doing this. Effectively, best mode is still a legal requirement. You're on Scout's honor to disclose it. However, if you don't disclose it, and if the office doesn't reject your application for failure to disclose it, not that they really examine for it, then your application will never, your patent will never be held invalid for failure to disclose best mode. Now, there are lots of people who say, God, there's going to be some way it's going to still sneak in there. We tried to catch all of those ways, any way that it could become a problem. It's actually discussed in the second part of my article, which will only be published in June. And I think I note in that section that no explanation is really given for why it was done this way, nor is one apparent. The one thing I will say in defense of it is for all the people who complain, gee, why didn't you just repeal it outright? That would have been so much better. This is terrible. I've never had someone say, in fact, I'd rather go back to the old system where you can litigate over best mode. And what was the inventor aware of at the time? Not what was actually the best mode. What did he contemplate? Let's drag him in here and depose him 15 years after the fact. So it's clearly a step in the right direction. But you're right. It would have been much cleaner to have just repealed it entirely.
Judge Smith?
I'm, of course, tempted to ask Mr. Mittal if he were drafting it, what would he have drafted, since he's already suggested that, since he said that he contemplated that he would draft it some other way, what that is. I would also ask him this question. What does he think Thomas Jefferson would say if he were to learn that now the inventor need not disclose what he thought was his best mode in the grand bargain where Jefferson said the monopoly only should be given at high cost where essentially the best of what the inventor has been put forward to the public?
I'm pretty sure Jefferson would have said. Jefferson, by the way, is believed to have played a role in the drafting of I think it's the 1793 Act. There was the 1791 and then the 93. And a lot of what's in the 1793 Act, such as 101, is basically dates, although it can be traced directly. The language is identical in the 1793 Act. If you raise best mode with him, I'm pretty sure he would have said, what's best mode? Because I'm pretty sure it was only added to the statute in 52, in the 52 Act. It definitely doesn't date back to the origin. And it's just subjective. It's not what actually was the best way of doing this. It's what did the inventor contemplate at the time. And if the inventor later thought of a best mode, he doesn't need to disclose that. It's only at the time of filing. And it's just a trap for discovery and depositions. It's one of the things that makes patent litigation much more expensive than it should be. If I'd been drafting it, we should have just repealed it entirely.
Any other panel members? Yes.
One more
Ms.
comment.
Bargold?
So from the Patent Office examination perspective, when we implemented the provision, we issued a memo to examiners requiring them to continue to examine for best mode. Nothing in the MPEP is changing. However, it's my understanding the office rarely makes a best mode rejection. I mean, we would have to learn that there's a best mode problem, likely through some kind of inventor declaration coming before the office to even tee the issue up for us. And then second, we have become aware of concerns, like you mentioned, of possible disciplinary consequences for an inventor or for a practitioner who fails to disclose best mode, and the kind of tenuous situation between disclosing it, yet it not having any teeth in litigation. So the office is going to be investigating that disciplinary issue further, and you're likely to see some guidance coming out from us. Not that we don't have enough to do already, but in the future about how we intend to handle best mode and ethical violations.
Yes, sir.
In the spirit of dialogue.
That's like with all due respect.
Let's talk about estoppels.
almost none. The ideal estoppels are the ones that are in this bill that passed the Senate in March by a vote of 95 to 5. Those estoppels for inter partes and post-grant review bar you from raising, if you take a patent through IPR or PGR, you're subsequently barred from raising any issue that you raised or could have raised in that proceeding in either any subsequent office proceeding for both inter partes and post-grant review, and in any civil litigation after inter partes review. But in that March Senate bill, you were only barred from raising issues that you actually raised in the PGR. The estoppel only applied to those issues for subsequent civil litigation. So if you challenged a patent in this new post-grant review, all issues first 9 months after the patent is granted, and then you later end up in a litigation, you can still raise issues that weren't actually raised and decided in that post-grant review. The bill that was finally signed into law could have raised estoppel to civil litigation for post-grant review as well. I actually didn't become aware it had done this until several weeks after President Obama had signed the bill into law, and I'm pretty sure none of the staffers or members who worked on it were aware. Tracing it back, the House bill as introduced also only applied actually raised estoppel to PGR for civil litigation, and it appears that it was changed when the bill was reported by staff who were charged with making technical corrections and who apparently thought, well, gee, if they put in could have raised everywhere else, they must have meant it here as well. Those staff didn't bother to tell anyone about this. None of the rest of us caught it, and so now it's in there. That's obviously something we'd like to fix, because if you apply could have raised estoppel to civil litigation after a PGR, you basically can't challenge a patent subsequently on any validity grounds in civil litigation if you take it through a PGR. And remember, you can only start a PGR within the first 9 months after the patent is granted. There's limited discovery, limited time to just figure out what enablement or other potential problems there are with the patent. And so if you tell industry, hey, yeah, go ahead and bring a PGR challenge within the first 9 months, but if you fail and the full patent or an amended version comes back out, you'll essentially never be able to challenge it on validity grounds again in civil litigation. If that stays the law, no one's going to use this proceeding. And that was pretty much universally understood. Every previous version of the bill always limited the could have raised estoppel in PGR. Didn't apply could have raised estoppel to civil litigation following PGR. And I'm sure there will be an effort to fix that, because it looks like it would severely damage the proceeding. Very few people would be willing to ever use post-grant review if they're effectively giving up all of their validity defenses for the next 20 years of the life of the patent. The other estoppels, no one's talking about changing those. So all of the inter partes stuff is going to stay the same, and no matter what. And could have raised estoppel will continue to apply to subsequent office proceedings after a patent is taken through PGR.
Any other comments? No. I think the gentleman over here, actually, you raised your hand previously.
Yeah, no, it was back a couple questions ago. I guess the cases we covered at the Academy are no longer, may no longer be valid. The Corset case and then
Corset clasp case, yeah, it's a great case. It was the inventor invented a improved clasp for holding together a corset. This is a case from like the 1870s. It's the origin of the secret public use doctrine. And the only evidence was that he'd given this special corset clasp to a lady friend of his, that she wore it under her dress, and the Supreme Court said that's a public use of the invention and invalidates the invention. There's a great dissent from Justice Miller where he says, if this is a public use, I cease to understand what's the difference between private and public anymore. But that was the dissent, and that's been the law ever since. It was literally about 1870 until the AIA.
Any comments from the panel on that? Stay away from that. What about the side?
I would like to
sorry,
explore a little bit more the reasonably could have raised estoppel provision for PGR, and just pose to Mr. Mittal the question of whether there's any contemplation of validity challenges that would still be open to a petitioner seeking to challenge the patent. Specifically, whether reasonably could have raised is envisioned as also encompassing art that was not discovered because it was somehow remote and unavailable and then subsequently became available? Are those challenges also precluded?
There's some ambiguity about what reasonably could have raised means. Before, for inter partes review, the standard was just could have raised. Congress added the word reasonably, thinking courts would probably read it that way. I mean, we don't want to punish people for failing to raise an issue that they couldn't have reasonably raised. There's legislative history that basically says, something you reasonably could have raised is something that a skilled searcher likely would have discovered through a diligent search. So if it's a PhD thesis, in a university in Siberia, even if properly cataloged, unless a printed publication, we assume a court probably wouldn't say that's something you reasonably could have raised. But there is, it's up to the courts to some extent to decide, is this something that if this person had been diligent, and had done a thorough search, we could reasonably expect them to find it.
What I had in mind more was the PhD dissertation at Catholic University, and maybe the catalogers are 2 years behind in cataloging all the dissertations so that it becomes available after the proceeding has concluded.
I assume that wouldn't be reasonably available. It's not even a printed publication until it's properly cataloged, I'd assume. So, yeah, that'd be something that wasn't... it's not something that reasonably could have been raised. Although I guess, would it even be prior art before it was properly cataloged? So yeah, so it's, so the patent owner wins no matter what under that one.
It strikes me that this is a new cottage industry for experts. Now we're going to have expert reports on this idea of reasonably diligent searches for art and whether there's actually an estoppel.
There's money to be made.
Not that I'm looking for more expert reports, but it sounds like an area.
As the two refuges of so far that we've seen in the legislative process is do a study or leave it to the courts. This gentleman over here.
Yes, this is Ms. Donald. You said something about how you're going to do research on the diversity on people who file. Is that correct?
The diversity study.
Right. The program asks the agency to set up methods by which we can collect diversity information on applicants.
The question is, why?
I think if you read Mr. Mittal's paper, he will explain to you that there was and I don't remember the congressperson's name who introduced the provision, but the idea of the methodology was to examine whether underrepresented groups in the population are making patent application filings. If they are not, my understanding is there's going to be an effort to perhaps educate these groups on the benefits of filings, how to make filings, etc. So until we know where the filings are actually coming from, we can't engage in outreach to groups who aren't using the patent system to educate them on the benefits and promote making patent filings and how it can help them.
Anyone want to comment on that in the panel?
I'll just add, that was an amendment adopted in the House of Representatives, not in the Senate. And there's a tendency when you're managing a bill on the floor that all kinds of people are throwing amendments at you. You got to make decisions about what you take and what you don't. And there's a tendency to say, thank God, all they want is a study. I don't care what they're studying. They're not trying to rewrite the definition of prior art or strip out first to file. All they want is a study. No, there's no long-term damage of
It
these.
just seems like now, like maybe 10 years ago, even this would have been more effective. But nowadays, I mean, you turn on the television and there's 1,000 commercials on you can file here, everyone's doing it. So I don't even know if that's really necessary to put money into.
I believe I even once personally apologized to the director for all of the studies that are required by the bill.
Well, you should consider submitting a comment to our RFI telling us that.
That's great. Anyone else? These gentlemen have asked questions before, but anyone else before I go to them? Yes, ma'am.
I have a question on the prior user's right and the extension to cutover art. I don't quite remember the cutoff date for the patent issuance, the issuance date of the patents against which the defense is available, but I recall it's somewhat retroactive.
It applies, the defense can be asserted with respect to patents issued after the date of enactment of the AIA, so last September 16th. Yeah, that potentially creates a takings issue if you apply the defense to previously issued patents. The patent's a property right. If you're creating a new exception effectively to that right, you're effectively taking away a property right. There is at least a strongly colorable takings argument, so there is a sense it couldn't apply, to patents issued before the enactment of the Act.
Any comments from the panel? No? Any other questions? Oh, back there, yes. Go ahead.
Is there any thought that any provisions of this Act would have a disparate impact on various subject areas? For example, natural processes may be less likely to get protection or things like that?
Processes?
Natural processes.
Might be subject to more of the secret type of...
Manufacturing processes? Or, prior user rights and the elimination of metallizing engineering really change your decision matrix for if you're a manufacturer using a secret process. I mean, under the pre-AA law, metallizing and engineering creates this perverse incentive to move your factory overseas because that's the only place. First of all, if you go overseas, you get a prior user right over there under pre-AA law. And also, you don't invalidate your own right to later decide to patent it. Now we have a system where there is a high thresholds for, but there is a prior user right for manufacturing processes. And with the death of metallizing engineering, you're also not punished for commercializing it. You have the option to try to patent it later. Obviously, if someone else discloses it or patents it, you're not going to be able to patent it if you wait too long. So now, part of the idea of prior user rights, frankly, was to encourage people to build their factories in the U.S. Now you get, if you use the process in the U.S., you don't have to patent it. And patenting is often ineffective for manufacturing processes. First, there are just too many, and you can't patent everything, especially overseas. And second, if you patent it, you give it away. The patent's published, and good luck figuring out if someone in a factory in China, is using your process. Now, under the AIA, if you meet the hurdles for establishing a prior user right, you can, once you start using that process in the United States and no one else files a patent on it for a year, the language requires a year delay. It doesn't matter whether someone later gets a patent on it or not. You have the right to keep using that process. You can use it at different facilities. You can expand the volume of your use. You can change the nature of your use as long as you don't infringe claims that weren't previously touched by the use that you established. So the goal, was to change the calculus that manufacturers face and create a strong incentive to, locate your next, chip fab or whatnot in the United States rather than overseas.
Comment from the panel? Yeah.
I've had some interesting conversations about this one already, and companies are looking at really implementing strong trade secret protections internally, physical and cyber protections, and really doubling down on the trade secret side because of some of these changes, and thankfully bringing some of the processes back in the United States. So it seems like this discussion's already happening.
Any other comments? Any other questions? Yes, sir.
I can't phrase this question very articulately because fortunately I haven't been involved in the inequitable conduct sort of proceedings, but my understanding is that there is a doctrine that's the fruit of the poison tree doctrine in inequitable conduct, and if the patent is found unenforceable for inequitable conduct, other related patents come in priority to that patent, and perhaps vice versa, I don't know, can also be found unenforceable. Is there anything in the supplemental examination that would change that and insulate patents, supplemental examination of a particular patent from related patents?
There's nothing in 257 that does that, although, again, it does give you the opportunity to eliminate, whatever it was that you did earlier as a basis for an inequitable conduct argument. So if you start the 257 proceeding in time, you can just take that issue off the table, and that issue, that aspect of the prosecution can't be used as a basis for an inequitable conduct attack. The bill also includes language that repeals all of the deceptive intent requirements in the law. And one of the areas where it repeals it is Section 288, which provides that other claims in a patent are still valid, even if one is declared invalid. Pre-AIA, that language, and I think actually the repeal doesn't kick in for a year, so not until next September, but pre-AIA, that language said those other claims are still valid absent deceptive intent. And it was that deceptive intent exception that courts relied on to say, well, therefore, inequitable conduct wipes out the other claims as well. You know, that deceptive intent exception created the basis for infectious invalidity, what I think the Federal Circuit recently called it the atomic bomb of inequitable conduct law. That's been repealed now, so the matter's not, you know, free from doubt. It'll have to be litigated, but based on how courts construed that exception before, 288 now should be a defense against infectious invalidity. If one claim is invalid, the others still stand, and there's no longer a deceptive intent exception to that to let the IC doctrine through.
Comments from the panel? Let me get. Yeah, there's two gentlemen who've been waiting patiently. Yes, would you?
Well, I just have one question about the post-grant review process, and if you've thought about ways to try to game the system. I remember from our civil procedure classes, there was something called claim preclusion and offensive claim preclusion, and there was a danger when a real small company sues somebody and they don't do a good job and they lose. That shouldn't prevent that issue from not being raised when a larger company or when the economics make the first litigation just not worth being thorough.
That's the Blonder Tongue case, isn't it, from '71 for civil litigation. So the fact that the fact that one guy challenged the patent doesn't prevent someone else from. There's effectively, what is it? God, the term is like defensive collateral estoppel.
Non-mutual offensive collateral estoppel. Non-mutual defensive collateral estoppel.
Well, I'm glad I wasn't in your class. I got that one wrong.
I teach it prep.
Okay. Wow.
That's fantastic.
And you know, you do in PGR. So you know that's settled for the standard in civil litigation. In PGR, the estoppel applies to real parties and interest in privies. There's some ambiguity about what's a privy, but it's basically means successors in interest or people who had a relationship with each other with respect to that property. My guess is courts, and there's legislative history to back this, courts will read that to mean parties to a joint defense agreement. So if 5 different parties are attacking the same patent, one of them starts a PGR or an IPR, all of them will be deemed privies, and the others can't then, you know, raise the arguments in civil litigation that they could have raised in that inter-parties review. However, a party that's not a privy or a real party of interest wouldn't be affected.
Okay, so then in that way it's different from that nature. So that's how you limit it. It's got to be a partner or a partner.
Yeah, there's only estoppel against the party, against someone who's a party in the original one. So there could, right, so,
Even in civil litigation.
right, even in civil litigation, only you had to be a party in the first suit to be estoppel.
And indeed, the comments with respect to the estoppel provisions, apart from the reasonably could have raised, the other thing that has invoked the most comment or spurred the most comment is what is a real party in interest? Is it really the party just on the papers, or is there a shadow party out there who's
There was like an industry group. Yeah.
an industry group?
Represent the industry group.
Yes, or the greater fear is the creation of shell entities to bring the action in a way that purposely disguises who the real party in interest is, so that they seem to be disadvantaged unfairly in the kind of situation you describe where they're held to the preclusion, when in fact they're not unfairly held to it at all because they are in fact the controlling party or in privity with the party who brought the action.
Any other comments? No?
I think
Yes,
it'll be
sir.
interesting to see as this rolls out how we get to really figuring out who's part of the estoppel story, and this idea of really exposing the joint defense relationship is going to be an interesting one for courts to really understand when estoppel applies.
Great. Yes, sir.
Just a comment first before my question, going back to Judge Smith's point. This is a very real issue. I was approached by a very prominent company who wanted to find out if I would set up an entity whose job it was to sell subscriptions
But what I was going to get at, from another real-world perspective, let's talk about covered business methods. It seems to me that the way that statute has been created, essentially, you have created a class of patents, whatever the covered business methods are, that are essentially unenforceable. Because as a practical matter, all it takes, let's take the Wall Street banks, for example, and push this through. The way I read it is you have this automatic stay provision, essentially. So
Not automatic, but close, yeah.
But about as close as you could possibly imagine, I guess, except violating the separation of powers. And so you bring, so any entity that has been sued or threatened with suit, whatever that means, can bring a covered business method proceeding. And then the court, even if the trial is just about ready to start, has to stop. And then you get this interlocutory appeal to the Federal Circuit. Then another covered business method proceeding can be filed by another defendant because of the new joiner provisions, because you can't sue them all together. So that one breaks that one, and up it goes on top of the other. Judge Smith, how are you going to manage all this piling on, this, as Judge Michelle calls it, gang tackling of the patent by multiple defendants and multiple suits that deliberately stagger these CBM proceedings? And also on top of that, there are no estoppels in that law except for what you actually raise.
It's a more limited estoppel, yeah.
Very limited, the way I read it. So you could have different groups working together, different defendants working together. I'll bring up 101, you bring up prior art patent, you bring up prior art printed publication. What's going to prevent the core patent owner from being completely prevented from enforcing their rights?
Well, let me say, and this is just a minor point, going to one aspect of the situation you described, the sued or threatened with suit. I think the proposed rules and the practice guide make the threatened with suit a little more definitive than it might appear to be on the surface. And I think at least some of the comments are pleased with that we've received, indicate some level of agreement with the approach we've taken there, and making it a bit more definitive as to what factors are sufficient to demonstrate being threatened by an action. More generally to your question, however, I think what you're speaking to has more to do with what the statute calls for than any control we might put in place. The simple fact is if the challengers meet all the requirements to bring the challenge, we have only so much discretion not to invoke the proceeding. That said, generally the statute is very permissive with regard to granting the director the power to decide the number of CBM proceedings which will be allowed in any given year, and in fact puts in a certain discretionary fudge factor even not to allow a proceeding when the strict requirements have been met. I don't think all of that's necessarily been figured out. I think the director is aware of the latitude he has, how he will choose to exercise it. We will see. Janet, being the director's lead AIA person, may have some greater insight as to how he will choose to do that.
I do think that you're going to see more CBMs filed than you realize.
Any other comments from the panel?
You know, Rod, I just note that the main protection that's built in to the proceeding for the office in both Section 18 and PGR as well, there's a very high threshold for starting the proceeding. You basically have to present a prima facie case of invalidity. It's actually articulated as even slightly higher than the IPR standard. It's evidence which, if not rebutted, destroys the patent, or a claim is more likely than not invalid. And you know, for several years, having a high threshold for starting both PGR and inter partes had basically been Patent Office staff's number one request for reform. The people I worked with at the time aren't any of the people present here. Some of those folks have retired, et cetera. The office doesn't have fixed views, but for several years, starting in about '07, we heard a lot of concerns from the office about its ability to handle post-grant review, and we started to hear a lot more concern about inter-parties review as the number of inter-parties proceedings really started to climb. The office really felt like it was drowning under them, and they sat down and looked at what's going on, how can we fix this, and the number one reform they wanted was that elevated threshold. One thing we also looked at, there were drafts of the bill at various points that basically limited successive proceedings against the same patent for PGR and IPR. So if one party brings an IPR, it would be almost impossible for anyone else to do so. And one of the reasons we ended up not taking that as approach is the office felt that the threshold was so high that it's very unlikely that more than one challenge, more than one invalidity attack would meet that threshold at the outset against one patent. They basically thought with that elevated threshold, there just aren't going to be multiple grounds brought by multiple petitioners that meet that threshold.
Unfortunately, we're out of time. Any other comments from the panel?
That said, the statute does allow the fact of earlier proceedings having been brought to be considered in whether another one is invoked. So, yeah.
Okay. There's also the aspect of swift justice in front of the Patent Office. The statute requires the provisions to conclude in 1 year from institution, so that will help speed things along.
Some people might.
I think unfortunately, we have to conclude here. Was this a great panel or what? Give him a hand.
Professor Winston and I would like to thank all of our speakers very much for being here today to discuss this important topic of the implementation of the AIA. And we should have mentioned at the beginning of the program that this is our second annual Dean William C. Robinson Intellectual Property Lecture. And Dean William Robinson, for those of you who don't know, was the founding dean of our law school. And he was also the author of The Law on Patents, which at the time was the leading treatise on patent law. So I think that Dean Robinson would be thrilled with this discussion here today of the America Invents Act, and I think this is a perfect way to honor him. Professor Winston and I would also like to thank Judge Damage very much for serving as our moderator today. Judge Damage, we are extremely grateful to Judge Damage for everything he does for our law school and for the intellectual property program. So thank you very much, Judge Damage. Finally, we'd like to thank everyone for attending and for coming, and we hope you will stay to enjoy a reception in the atrium. And also, if you haven't signed up on the CLE sheet, please make sure to do that. There will be some sheets outside. We just need your name and your email address.
And if you have the CLE sheet, can you please make sure it gets back to us rather than taking it home with your wonderful notes on it? We would all greatly appreciate it. And I'm going to put in one more plug. When you go to the networking reception, can you please find some of our students? We have many wonderful students who are here in attendance today. And just talk with them. Raise your hands. Raise your hand if you're a student. If you're a student. So take a look around, and please go talk to them. Tell them what you do. Ask them, and they're here to meet y'all and to hear from our wonderful and distinguished panel. And we really appreciate this. And thank you, guys.
Thank the professors, too.